Could a case about homemade whiskey finally change federal weed law? I'm Amanda Connor. I'm a former kindergarten teacher turned lawyer, and today we're looking at the Commerce Clause, whiskey, and weed. First, the Commerce Clause. The Commerce Clause says that Congress can regulate and oversee anything that goes between the states. It can regulate interstate commerce. How does that play with whiskey and weed? Well, it has to do with two cases. First, the weed case or the cannabis law case, and that's Gonzalez v. Raich. In Gonzalez in 2005, the United States Supreme Court was asked to decide if someone growing weed in their home in California, used in their home in California, and never going to another state impacted the Commerce Clause such that Congress could regulate it. And the Supreme Court said, yes, homegrown weed used at home could impact interstate commerce of cannabis, and thus found the Commerce Clause applied. And now, whiskey. Whiskey may be the case that changes it all. Why? Because there's a gentleman, Ream, that has brought a case that says, I make homemade whiskey, drink it in my home, and it never crosses state lines. How could my homemade whiskey impact interstate commerce? The Supreme Court has not agreed to hear the case yet, but if it does, it could decide that homemade whiskey drank at home does not impact interstate commerce, whiskey sold across state lines. And if it did, it could just be that a whiskey case changes weed law in the United States. Will whiskey finally be the pathway to lessening federal prohibition on cannabis? Cheers.